court to stop them, and they did because they won. This bill, in spite of the Secretary of State's office having a terrible track record when it comes to voter rolls, gives the Secretary of State more power over your local county voter registrars. It's your local county officials who get to make these decisions right now. They no longer do. They're subservient to the Republican appointee Secretary of State under this out-of-bounds resolution. There's a lot of egregious things in this resolution. I'm going to go through them chronologically. I think this is the most egregious. Many of us are familiar during the early voting period with souls to the polls. What that means, for anyone who's not aware, is that there is a great tradition in the African American church in this country that after services on the Sunday of early voting, that voters leave the service and go to the nearest early voting polling place to cast their votes, to make their voices heard, to follow in the example and the footsteps and the leadership provided by Dr. King and so many others, John Lewis, who fought and bled for the right to vote. It's a way to honor their sacrifice by casting those ballots however they choose to cast them, but doing that as a community after worship on Sunday. So what this resolution says is that all of a sudden now you can't have early voting begin on Sunday until 1 p.m. So if you were at that early 7 a.m. service, or you're at the 9:30 a.m. service, or the 11:15 service, you're not going to be able to go vote right after church. You're going to have to wait. And when you do get there, guess what? There's going to be a line. There's going to be a line to be able to cast your vote on the Sunday, the only Sunday of early voting. That's the point. You make it harder to vote, and you by changing the hours, and you make it harder to vote by creating a line when people get there to vote. It's shameful. The next egregious provision is on poll watchers. We've talked on this floor before about partisan poll watchers being sent in to predominantly African American and Hispanic communities to intimidate and to harass the voters, and in some cases the election officials. I told my story on this floor before from my time in Tarrant County many years ago, where that's exactly what the Republican Party did, and they admitted to it. They were sending them into Southeast Fort Worth, into the African American part of town. They described them as, quote, problem areas. We saw a leaked video a few months ago from Harris County, where the Harris County Republican Party said, we are trying to recruit brave people who will go into these really scary areas in Houston to make sure that the integrity of the election is upheld, please. They're looking for people who are willing to go and intimidate black and brown voters. And this resolution makes it easier for them to do that. On vote by mail. It's not easy to vote by mail in this state to begin with. We know that. But this bill is going to make it more difficult if this resolution is adopted, because it's changing the definition of disability. So right now you have to be 65 years of age or older or disabled. This is going to make it very specific how you can be qualified to vote by mail on the basis of disability. The Texas Supreme Court ruled last year, when many people were trying to vote by mail during COVID because they didn't want to get sick, that a voter's word is good enough. If the voter believes they can't go vote because of a threat to their health or to their safety, that's good enough under the law. This resolution says that's no longer good enough. We're going to make people, when they return a ballot by mail, include their driver's license number or the last 4 digits of their social security number on it. Why? I don't know why. I've never heard of a problem before that we couldn't determine if a vote was valid because we didn't have someone's driver's license number. It's another intimidation tactic. And then there's this one, overturning the election. This is on page 15, members, of the resolution. So now we're going to have a provision that says, and I'll read from the resolution, if the number of votes illegally cast in the election is equal to or greater than the number of votes necessary to change the outcome of an election, the court may declare the election void without attempting to determine how individual voters voted. So, members, are you okay with that? Are you okay with a judge being able to overturn an election, perhaps your own election, simply because the math says that, well, you know, we think that there are some illegal votes and the margin was kind of close and I don't have to prove how people voted, but you can overturn the election. Are y'all really okay with that? That's what this resolution would allow for. And so, members.
Ms. Beckley, for what purpose?
Mr. Speaker, will the gentleman yield for questions?
Will the gentleman yield?
I'd be happy to yield. I'll just say this resolution is far afield from either the House passed bill or the Senate passed bill. That bill is bad and egregious enough as it is. We don't need to make it more egregious by going outside the bounds here at literally almost the 11th hour before on the second to last day of the legislative session. I ask you to vote no on this resolution. I'd be happy to yield for questions.
The gentleman yields.
Thank you. Thank you, Chairman. Mr. Speaker. That last section where you were talking about the judge overturning elections, we never heard that in committee. Not a version of that. That has not been vetted by the people of Texas. That is just magically here. Were you aware of that?
Well, I was aware that it had never been discussed in the Elections Committee, which I know you have served and worked hard on all session. It's certainly never been discussed on the floor of this House. I don't believe it had been discussed in the Senate. I'm less sure of that. But I know for certain it was not in either version of Senate Bill 7 passed by either this House or that Senate earlier this session, and it should absolutely not be on this floor today.
Do you feel like that is fair to the people of Texas? That this has not been vetted by the people of Texas in the processes that we uphold in this body?
It's absolutely unfair, Representative Beckley, to the people of Texas, to the voters of Texas. We have election contests provided for under our laws today. And there are members of this House who have gone through election contests in rare circumstances, but it does happen. The laws provide for an election contest, so both parties, both candidates, as the case may be, can make their case and a judge can make an ultimate determination. This language is completely unnecessary and extraordinary in its breadth of how an election could be overturned.
Do you think that was based on the big lie?
I do. I think, you know, I've talked about that before on this bill, and I'll probably be talking about that again this evening on this bill. But the reality is, you know, people have promoted the big lie that somehow Donald Trump actually won the election that we know that he lost last year.
Mr. Speaker.
Mr. Ranchier, for what purpose?
Will the gentleman yield for some questions?
The gentleman is out of time.
Okay. Thank you, Mr. Speaker.
I ask you to vote no on the resolution.
The chair recognizes Mr. Busey to speak against the resolution.
Thank you, Mr. Speaker. Members, I want to first thank Chairman Turner, who just walked us through so many terrible things in this resolution that's before us. I want to really sink down into one section that he closed with. But that's how important it is. I see everyone's on their cell phones and reading other things, and I think it's important that we think about what we're about to vote on. This is a section that was added. We're going outside of the bounds. That means that we never had this in either the Senate bill or the House bill. There's 150 of us on this floor, but it's not 150 people that we represent. We represent 29 million Texans. When we walk around with the impact of almost 200,000 people for each of us here. 29 million Texans whose voice are about to be hindered at the ballot box if we pass this resolution. Section 232.063 on page 15, it says overturning election. If the number of votes illegally cast in the election is equal to or greater than the number of votes necessary to change the outcome of an election, the court may declare the election void without attempting to determine how individual voters voted. What does that mean? This adds an entirely new section that makes it easier to overturn an election. Previously, those seeking to overturn an election were required to show that the alleged fraud actually resulted in a fraudulent win. The new provision lowers the threshold to simply require evidence that alleged fraud could have resulted in a fraudulent win, meaning you no longer have to prove it. So all of you out there, as myself, we all have political enemies. They could use this to overthrow the voice of the people, to overthrow the voice of Texans. You're not one person when you're here. You're almost 200,000 people. You're the voice of Texas. Do we want to throw out our ability to let the voices be heard through elections? Because if we pass this resolution, we no longer have to prove voter fraud to throw out an election result. We can simply do it.
Mr. Speaker?
Ms. Gonzalez, for a
Does the
purpose.
gentleman yield for some questions?
Gentleman, yield for questions?
I do.
He yields.
Representative Busey, there were some amendments when SB 7 got voted out on the House floor that were agreed upon, right, and voted out of this body.
That's correct.
And were these amendments stripped out in the final version of the bill?
I think many of them were.
Do you know why that was?
No idea.
In fact, the bill came, would you agree with me that the bill came back worse?
Not only did the bill come back worse, and I think this is what's so important as we talk about this resolution, it's not that the bill is just worse. It's not just that our side versus your side doesn't agree with it. It's that this resolution is adding stuff that we never heard, that we never debated, that we never got to have our constituents come and testify on. This resolution goes outside the bounds of what we dealt with. That means the voices of Texans were not heard in this debate.
And so would you agree that this is the process circumvented the opportunity for people to be able to give their testimony and in committee?
You know, absolutely. Going outside the bounds may be within the rules, but it's our job, I think, to do this in the clear of day where our constituents get to have their voice heard. And this resolution did not give that opportunity to our constituents.
So the people deserve to have a public hearing on this, and we deserve to have that before it getting put into this final piece of legislation that was done behind doors, right?
Absolutely.
But did you have an opportunity to review, have time to review?
I mean, I think the Senate got this late last night, if I remember, based on what I was hearing over there. This is a 20-page outside the bounds resolution. We heard Chairman Turner talk. I don't know when we've seen something that big to really process it for the 150 of us to have the time to process that. I think the time has been short. I think I can speak for the whole body of the House that this isn't the bill the House sent over. This resolution takes it way beyond that, and I don't think that was the intent of Republican or Democrat on this floor to have this resolution here.
Thank you.
Mr. Speaker,
Mr. Ranchier, for a purpose.
will the gentleman yield for questions?
The gentleman yield for questions.
Yes, sir.
He yields.
Thank you, Mr. Speaker. So the provision, particularly among all of the offensive provisions of SB 7, one of them that we are now seeing for the first time is changing the evidentiary standard and the process for overturning elections, which a judge can do over the will of the people. And you talked about that in your layout, is that right?
That's correct, sir.
And so I just want to highlight for you, and you're probably aware of this since you've followed this process for a while, that we have multiple members whom at least I've served with that have been seated in this body after special masters have heard their cases. And if I can walk some of those through those with you, I'm sure you're familiar with the names, but
I'd love to know more.
Hubert Vo, who's in my class, won by 16 votes out of 50,000 votes. And there were rampant allegations by his opponent of voter fraud in the Vietnamese community. And a special master was convened in this body, and the evidentiary standard was not only that they had to prove that the margin of victory, there were votes that exceeded the margin of victory that had been called into question, and they said there were about 450 or 500 fraudulent votes, but they also had to prove that those votes would have been for Representative Vo. And do you know what the outcome of that special master's convening was?
I don't, and I think we all need to be reminded.
So the outcome is that Hubert Vo is here today as a member of the legislature because there was one fraudulent vote that was found by Special Master Hartnett, who's a Republican from Dallas County. And do you know what that vote showed?
What did it show?
It showed that a non-citizen had voted, but he wasn't Vietnamese, he was Norwegian.
Okay.
And that person had voted straight ticket Republican.
Oh.
And so despite all of the allegations, and in this bill we're changing the evidentiary standard for that, and suddenly saying a judge can overturn an election just by the allegations of votes in excess of the margin of victory. And I find that troubling, and I hope you do too.
Well, and to understand what you're saying under this new standard, Hubert Vo, elected by his constituents to be here and to fight for them, may have been thrown out.
Exactly right. Exactly right. Same thing happened in the case of Donner Howard, who won an election by 4 votes over of 50,000 cast. And there were widespread allegations of voter fraud there as well. And when they convened a special master, you know how many votes they found that were fraudulent? 0.
0. But under this new standard, crying and making accusations could get us thrown out of office that we were elected.
And I received a text from my longtime desk mate, Mark Strama of Austin, who had beaten Jack Stick when in 2004, and we all came in together. And the evidentiary standard that was used by the special master, also Will Hartnett in that case, was that they had to show not only that the margin of victory, those 500 votes that Mark Strama won by, were fraudulent, he actually also had to show that those votes were for him. And Mark Strama, who served with distinction in this body for 10 years, would not have been seated had we used the evidentiary standard in this bill. Is that right?
That's correct.
And that's a big problem. That subverts democracy. Wouldn't you agree?
Absolutely.
Thank you.
Members, this resolution will take away the people's voice. It will allow your elections to be overturned because of political enemies. Please vote no on this resolution.
Mr. Reynolds, for what purpose?
Would the gentleman yield for some questions?
The gentleman yield for
Absolutely.
questions. He yields.
Mr. Busey, you served on the Elections Committee, correct?
That's correct.
And you've served on the Elections Committee prior to this session, correct?
Yeah, that's correct.
Okay. And you understand that the out-of-bounds resolution changes the timeline on when people can vote the Sunday before Election Day. Is that correct?
That's correct, and it's disappointing. It's going to be detrimental, and it's going to really impact souls to the polls.
And when you talk about the souls to the polls, well, first of all, was that even discussed earlier, or when did we first see this new change of the time period on Sunday voting that you couldn't vote before 1 p.m.? When did you first see that?
I think it was in the last 24 hours or so that we first saw
So
this.
there was no vetting of that. Is that not correct?
That's correct. There was no vetting. There was no constituent input.
And in fact, it is clear based upon prior election cycles that African Americans tend to utilize the souls to the polls. Is that your understanding?
That's correct.
And it is your understanding that this would have a likely disparate impact among Black, Latino voters of color in the state of Texas. Is that your understanding?
Absolutely.
And is it also your understanding that Texas increased significantly in the 2020 election cycle for early voting in person through mail, and that the souls to the polls was a big factor in the African American turnout?
That's correct.
Gentleman's time has expired.
Please vote no.
Chair recognizes Ms. Johnson of Dallas to speak against the resolution.
Thank you, Mr. Speaker. Members, I rise in vehement opposition to this resolution allowing the out of bounds on this bill. Governor Abbott's appointed Secretary of State herself said several times that the 2020 election in Texas was safe, successful, and secure. Despite that, national figures perpetuated the big lie about the recent election, causing a flurry of pandering actions. A desperate search by our Attorney General, coupled with a bounty of $1 million by our Lieutenant Governor, produced no founded cases of election fraud in the 2020 election. This bill and the accompanying abuse of process that came with creating this discriminatory legislation has been highly irregular, and that's putting it mildly. The Conference Committee has added a provision regarding overturning an election that is truly undemocratic and offensive to the rule of law. It says that the court may declare the election void without attempting to determine how individuals actually voted. This provision allows a lawsuit to overturn an election without having to prove that the fraud actually occurred. Just think about that. Your election can be overturned without the other side being required to prove actual voter fraud. Additionally, the provision lowers the burden of proof to overturn an election. In other words, this election challenger is no longer required to show that fraudulent votes actually resulted in a win. The implications of this are unthinkable. To make matters worse, the provision was not in either the Senate nor the House version of the bill. This provision has not been subject to review and debate by the public. This provision has not been subject to review and debate by this body, and the provision has not seen the light of day until the last hours of yesterday. The purpose of the legislative process has been completely subverted by adding a terrible provision under the cover of darkness. What has happened to process? What has happened to the rules that this body is supposed to care about? We have rules and processes in order to have a just society so that people can have faith and confidence in the laws that govern them. Democracies are based on the rule of law whose formation are based on an open debate and participation and whose enforcement are based on true facts and fairness. When these principles fail, our foundation crumbles into autocracy, dictatorship, and tyranny. Why are we here if we're not going to insist that we have an opportunity to debate and be heard on important legislation? Make no mistake, the state of Texas will go to court again for this bill. We will waste millions of taxpayer dollars again defending this awful piece of legislation that seeks to disenfranchise so many Texas voters. This state has decided again to forego protecting voters' rights and straight to restricting them. And this is truly a sad day for the rule of law and the very foundations upon which our democracy rests. Thank you.
Mr. Turner, for what purpose?
Will the gentlelady yield for
Will the lady yield for questions?
Yes.
She yields.
Thank you, Representative Johnson. As I look at this resolution before us, and I know we've all been incredibly busy over the last several days considering really bill after bill and conference committee report after conference committee report, and I find it sometimes difficult to keep up with everything, yet as you have pointed out, we are all confronted here with a very lengthy report and a very lengthy resolution that frankly has been difficult for me to fully digest in the time we've had. You've mentioned several provisions already and others have too. Do you feel that you have been able to adequately understand all of this new material that's being presented to us on very nearly the last day of the session?
No, it's been very difficult. When you get the bill is, what, 60-something pages long? And when you get, at the very last hour, an additional resolution that's 20 pages long of new provisions and new materials that has never been before presented to this body, the Texas House of Representatives, to debate on behalf of all of our constituents, it's unconscionable. And it's unconscionable that we are actually sitting here doing this as opposed to rejecting this move by the Senate saying, no, we the House deserve to debate and we're going to honor those rules.
As I read the resolution, I'm seeing things that I guess are really going to affect large numbers of Texans in the voting and electoral process. There are brand new requirements for anyone who wants to vote by mail, for instance, that are in this resolution before us. And if I understand all this correctly, these are new provisions that have not been a part of this bill during the duration of its passage through the legislature, through the House, the Senate, the committee process up until now. Is that your understanding as well?
That is exactly my understanding, sir.
I see, for instance, there are going to be new requirements that a person is going to have to place on the outside of an application to vote early. There are new requirements related to what kind of disability is going to qualify for a person that wants to vote by mail on the basis of disability. Would you agree with me that those are exactly the kind of things that really deserve some detailed scrutiny in our legislative process and not the kind of thing that should be added at the last minute?
Well, exactly. You know, the right to vote is the most fundamental piece of our democracy. And this body should be looking for ways to expand everyone's opportunity to vote. We should be having online voter registration. We should have all kinds of opportunities. I do not understand for the life of me why we want to restrict people from mail-in ballot voting. This affects our seniors, this affects our disabled, this affects pregnant women, this affects all women with young kids who may not be able to take their children to go vote with them. And I just do not understand why this body and this legislature is trying to make it so hard for these families to go and cast their God-given right to vote in this country.
I feel, Representative Johnson, as I read some of these provisions, some of them I just don't fully understand exactly what they mean. And, you know, maybe I have time to ask a question or two here briefly in the few remaining hours or minutes we have, but it's definitely the sort of thing where I'd like to have had the opportunity to really study and consult with others that have read this carefully and could give me an opinion. And one example here on page 9 of this resolution, it talks about an application to vote by mail. I believe this refers to an application to vote by mail. On line 20, it says it must be submitted in writing and signed by the applicant using ink on paper. No longer possible to use an electronic signature or photocopied signature. But as I read that, I actually don't understand if that means only the signature must be in ink or the entire application must be in ink. Do you know the answer to that?
I do not. It's a vague question. You're right. Do you have the ability to fill in the blanks and print the application and just hand sign it, or are you required to hand write in the entire application? It's vague on this piece of paper. You and I are both attorneys. We also understand that words matter and precision matters. And this is the kind of thing that's vague. It causes confusion. If you're at home and you're trying to figure out what to do and you're trying to print a ballot, and if somebody thinks they're being great so that it can be legible and not confusing based on your handwriting, and they print it, is their ballot going to be thrown out? It's hard to tell based on this bill.
Well, and it's just one example and one small provision, but I guess the point that I'm trying to make is there are many of those in this resolution and many of those in the conference committee report that went outside the bounds, and that's what we have in front of us. Explicitly material that goes outside of anything else considered in this legislative session so far. And so I appreciate your comments about this, Representative Johnson.
Thank you, sir.
Mr. Speaker, will the gentlelady yield, sir?
The lady
Got
for
people
questions.
running both ways.
She yields for questions.
Thank
Yes.
you. Thank you, Ms. Representative Johnson. Unlike you, I am not a lawyer, but I am highly offended that we are going to make laws without completely vetting them. How is this going to play out in the courtrooms, do you think?
Well, I mean, like I said, there's going to be a lot of aspects of this bill that's litigated. There's a lot of issues that are, in my opinion, discriminatory, unconstitutional, and then there's vague and ambiguous languages. There's multiple bases by which this bill is going to be challenged in court, and that's going to be at the cost of taxpayers. And unfortunately, that is that we're not going to be able to fund really key programs that the people of Texas want, like healthcare and many other issues, because those monies are being spent on wasteful litigation because we are passing a terrible bill.
And maybe a history class or two about elections and maybe the 1965 voter protection.
And maybe a history class or two about elections.
Yes,
That's correct.
Thank you. So I think that everybody should be concerned, but I'm also concerned that we're just going to vote on this on party lines, and there are people in this body who are not paying attention and don't seem to care. Would you agree?
I think people in this body care, but it's disheartening how many people will come up to you privately and say, this is a bad bill for my constituents, but yet won't come to the mic and say so.
Ladies' time's expired. The chair recognizes Mr. Clardy to close on the resolution. Ms. Wiener, for what purpose?
I rise on a point of order under Rule 13, Section 9G, that the reasons for the suspension of the limitations are incorrect and misleading.
Please bring your point of order down front. All right, remember, this is a long one. Mrs. Weiner raises a point of order against further consideration of H.R. 2007 or Rule 13, Section 9G4 of the House Rules on the grounds of the explanation of reasons that suspension of the limitation is being requested lacks the required detail. Section 13 of the resolution suspends the limitation on the conferees to permit the addition of proposed Section 5.07, amending Section 86.002 of the Election Code. The proposed section would require a voter to enter certain personally identified information on the carrier envelope for a mail ballot. The proposed section also provides that no associating an individual voter within a ballot may be created. The resolution explanation states that the changes necessary to regulate the contents of the carrier envelope for a ballot to be voted by mail. Ms. Weiner argues that the explanation does not indicate that the record creation prohibition would also apply to the statement of residence form required under certain law to be included with a mail ballot. The rule only requires an explanation of the proposed change and not a detailed analysis of the effect of the proposed change to current law. Here, the explanation indicates the major purpose of the proposed change, and it's plain that the record creation prohibition is designated to prevent the association identifiable information on the carrier envelope with the ballot. The explanation complies with the rule. Accordingly, the point of order is respectfully overruled. That's the longest one ever. The chair recommends Mr. Clardy to close on the resolution.
Thank you, Mr. Speaker and members.
Mr. Speaker, will the gentleman now yield for some questions?
Gentlemen, yield for questions.
Not at this time. I think there's still important things we need to cover in the layout of the bill, but
The
thank you.
gentleman's going to continue layout of the resolution.
Mr. Speaker, is the gentleman going to allow me to ask questions before his time expires?
I'm hopeful to be able to move through this, but there are several important passages that we did not get to. And again, I think it's important that the body hear the layout of the out-of-bounds resolution. So let's see if I can talk a little quicker
I think
than
people
normal.
can read. I mean, I think it's important that I'm allowed to ask a few questions. I mean, it's
That's
maybe
fair to
5
say,
questions.
but with all due
So
respect,
I
the members
would
of this
request
body
that
can
you
read as
just
well.
allow me an opportunity to ask you some
The
questions.
gentleman does not yield at this time. Mr. Clardy, please explain the resolution.
Thank you, Mr. Speaker. So I appreciate the opportunity to close on this important out-of-bounds resolution. I do want to make a couple of observations just generally about the bill. First, this is a very important bill. This has been worked on for hours and hours, literally dozens of hours from the conferees on both sides of this building, with the Senate and the House. And I do want to thank those conferees, including Ms. Collier, Representative Canales. I know that we spent dozens of hours going through this bill, a lot of give and exchange. And so I know that the Representative Gonzalez wants to ask questions, but this is such an important bill. And when I look at this, there's nearly 20 full pages of out-of-bounds provisions in this bill, or in this resolution, but that's really less than of a total of a 67-page omnibus election bill. So a lot of this was done late. I don't get to control the clock, but I can assure you that the members of the committee did their absolute best, dead level best, to make sure we provided information to all members, including Representative Rose, and that we did everything that we could to make sure this was transparent, that we put all the copies out at the same time. We went through these things, and we went through these items very, very thoroughly. But again, for those members that weren't on the conference committee, that didn't serve on elections, that didn't hear some of these same bills in our committee, to hear those exact provisions, I think it's important to take the time and work my way through it. So if I return back to where we were a moment ago, and I'm looking at section 8.04 of the bill, where we amend section 232.008B of the election code, we were discussing how this affects election contests in the state of Texas, not just for general elections, but for primary elections as well. We changed these deadlines because it became obvious that there are problems in the state where contestants who want to challenge an election don't have ample time to build their case, gather the facts, and present those in a court of law. And so when you look at this, this gives you 5 more days. Yeah, I'm going to. 5 more days, challenging a primary where runoff would occur in 15 more days. So now instead of just 10 days, you have 15 days on a primary, and you have 30 days or 45 days instead of 30 on that election. Moving to Section 8.05, we create a special category of election contests based upon fraud. It makes the standard under Section 232002, makes the standard for this review a preponderance of the evidence standard. But then what the 232063 does in Section 8.05, it codifies that you do not have to have a vote harvester testify how they voted each ballot that was cast, so long as you can prove that they cast more illegal ballots than the number by which the contestant lost. Yeah. So you still have to prove fraud in all of those elements. Now, if we move to Section 8.06, this is something that was discussed to be codified in HB 6, but it didn't make it onto the floor, but it is here, the conference report. What it does is in the election code, the writs go to the Court of Criminal Appeals as opposed to those that go to the Supreme Court of Texas. And then moving towards the end of those matters that are out of bound, in Section 8.09 of the bill, it cleans up the expedited docketing for election procedures. And then finally, in Section 9.02, there's a clarification of intent that we think cleans up a provision that was in the Senate version, and it requires standardization of the forms concerning felony judgments and the affirmative finding and instructions to the convicted defendant. So that completes the layout, Mr. Speaker, but at this time I'd be happy to take questions from Representative Gonzalez.
Thank you. Representative Clardy, would you agree with me that H.R. 2007 has 22 substantive additions that it adds to SB 7 that were not either in the Senate or the House engrossed versions of SB 7?
I'm not, let me check one thing. I had, in my count, I had 23, not 22, but I would disagree with your characterization. Many 23 of these had been included as either parts of the House bill, but these were provisions that hadn't been talked about and had been discussed. But there were a number, yes.
And of these 23 substantive changes, do you know which ones of these we actually heard in the House Elections Committee?
You and I were privileged to serve on that committee, and I appreciate you being our vice chairman of that committee. I would have to go through, I'd hate to try to guess. I could probably go one by one and get pretty close, but if you have a number, could suggest how many they were.
Well, I don't have a number, but I do know that they certainly all weren't heard in our elections committee. So you probably would know how many of these we actually voted out of committee.
It is my recollection, sir, we voted nearly everything out of the elections committee.
Do you know how many of them never saw the light of day in the House Elections Committee? That never even received a hearing?
That number I do not know. I know that there were some times we met and there was no light of day. We were there in the morning when it was dark. But if there's provisions here that we didn't, or sections of these 23 that we didn't hear, I'm unaware of that.
What would you say is the purpose of the committee process?
That's a very fair question. The purpose of the committee process is to allow the members of the committee to get more familiar with the elections code and to look at those areas that need to be addressed and to make the law of the state of Texas better. But most importantly, it's an opportunity for members to hear from not just us in this room who have opinions and ideas about the laws, but importantly to hear from the citizens of the state of Texas who take the time to come to testify in our committees and express their opinions. And some of those opinions we agree with, and some of those we don't. And there's some that you agree with that I agree with, and vice versa. But the opportunity of being a committee, the reason we do that, and the reason we have this exchange in public, televised for the world to see, is so we can exchange ideas about how we can make elections in Texas fairer, more open, more transparent, but also more secure and preserve the integrity, which is vital for a democratic republic to continue to exist.
And I agree with you with the purpose of the committee process. But if some of these bills were never actually heard in committee, then the public never got the opportunity, nor did the committee members get the opportunity to hear these changes or these substantive changes in 2007 that never even came before our committee, but yet were added to this final version of the bill. So people aren't having the opportunity to give testimony. We didn't have the opportunity to ask questions, to hear from witnesses, to ask questions from the AG to see how these certain provisions would be enforced.
Right, and that's a fair point. But I would also say there were a lot of times we have the opportunity as individual members to visit with those witnesses and those stakeholders and those people who are elections professionals throughout the state and the folks that serve in the Secretary of State's office or in the Office of Attorney General. Yes, we obtain that testimony from witnesses at the hearing, but we also obtain information from people outside of the hearing. And oftentimes I would challenge any member in this House to say that there were times they've served in the committee when well into the process they realized this was an idea we should have thought of. I mean, I would like to think we're deliberate and we want to think through, we try to be diligent and capture the ideas early, but sometimes part of the process is to make us think of things that we should have thought of before. And so I certainly don't think it's appropriate for us to turn a blind eye or a blind ear to ideas that have been brought forward that are appropriate to belong in a bill like this, an omnibus bill that's designed to protect elections in Texas and be fair to all Texans.
Besides the budget and in your service here, and I can't recall how many terms you've served, but I know you've been here for quite a few terms, correct?
This is my fifth term. We're 2 days away from completing.
So
Yes.
in your 5 terms of serving, and besides the budget, can you ever recall an outside of bounds resolution that was 20 pages long and made 23 changes to a bill?
Actually, I can beat that. I don't see him on the floor, but I remember Representative Kemple at one time amended a bill with about 20 pages with about an 80-page amendment with going outside of bounds. But now, I'm sure that was entirely appropriate and like this bill was designed to.
So you remember one other time.
Well,
so it doesn't happen very often, right?
You know, and I don't want to pick on Representative Capriglione, who's prone to bring his third reading amendments, but, you know, the procedures allow what we're doing here to come forward with out-of-bounds amendments, and that's why we lay this out. We publish it to the members, and it's available to everyone to look at. I mean, one of the things I was wanting to address that we just got in last night, which I was unaware of, was the fiscal note on this bill that we've not been able to talk about. And that is a concern, but I think it's not an irreconcilable concern. But we've pushed this information out in a very public and open way, and we have through the start of this process.
Do you recall any elections bills in the past that utilized, this many outside of the bounds changes?
I don't have a specific recollection. Of course, I think like you, this was my first time to serve on the elections committee. So, but in prior sessions, I don't remember that. But that's why I wanted to serve on this committee, and I was honored the Speaker allowed me to serve. This is an important issue for all Texans, and so the opportunity to be here, work with you, work with others, go through the process. I really do feel like we've made good changes here, both out of bounds and in the bill itself. I think that we in the House stood firm on the agreements that were made with our colleagues across the aisle before we voted on HB 6, and I think the bill as it stands is a very, very good piece of legislation. I believe it will serve the people of Texas well.
Thank you, sir.
Thank you. Mr. Speaker,
the gentleman's time's expired. The question occurs on the adoption of H.R. 2007. This is a record vote required by the Constitution. The clerk will ring the bell. Have all members voted? There being 79 ayes and 35 nays, the resolution is adopted. Is Mr. Kane on the floor of the House? The chair recognizes Mr. Kane.
Mr. Speaker, I call up the Conference Committee report on Senate Bill 7.
The chair lays out the conference committee report on SB 7 and recognizes Mr. Kane to explain the report.
Thank you. Mr. Speaker, members, first, I want to publicly apologize to Representative Beckley. On May 7th, this body unanimously adopted Floor Amendment 20 by Rep. Beckley, which contained her bill, House Bill 661. The language would have allowed counties like Denton and Liberty to participate in the countywide polling place program. While the policy of the amendment can hardly be said to be a priority of my party, the amendment was in every draft of the Conference Committee report. The final Legislative Council version was delivered very late on May 27th. In reviewing the final version, I noticed several things that were supposed to be there were missing. One of those things was her amendment. I gave my word to my former desk mate that I would fight to keep her amendment in the report. I still don't know what happened or why it disappeared. I'm sorry. If the governor calls us back for a special session, I'm committed to hearing and voting on your bill first. This Conference Committee report is the product of many meetings and calls between members of both parties in both chambers. The bill contained in this Conference Committee report seeks to make it easy to vote and hard to cheat. It protects every single Texas voter. Much of the provisions contained herein are designated to clarify existing law and to prevent honest mistakes from being criminalized. Article 1, Section 2 of the Texas Constitution provides that all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. To this end, in making our state constitution, the sovereign people of Texas delegated their lawmaking power to the legislature in relation to election laws. The legislature finds authority in Article 6, Section 4. Senate Bill 7, also known as the Election Integrity Protection Act of 2021, is made in furtherance of this constitutional authority. Section 1.03 contains legislative findings that reflects Floor Amendments 2 by Johnson of Harris, as well as Amendment 6, subsections 2 through 4 by Murr, the omnibus amendment crafted by several members of both parties, and parts of Amendment 4 by myself and Rep. Schofield in response to requests made by the NAACP. Section 1.04.
Ms. Collier, for what purpose?
I'd like to make sure that the gentleman will yield for questions.
Not this time. I've only got so much time, and I'd like to explain to the body the differences, and I'm not going to be repeating the same things that Representative Clardy said, and we only got so much time, so I'd like to finish, please.
Mr. Speaker?
Yes, Ms. Collier.
I move to have all the comments on the H.R. 2007, was it 9? 9, reduced to writing and placed into the journal.
Ms. Collier, 2007?
Well, the one on this, the H.R. pertaining to this.
H.R. 2007.
Yes, sir.
All comments related to 2007. Members have heard the motion. The objection. The chair hears none, so ordered.
Mr. Speaker?
Ms. Collier, for what purpose?
I move to have all the comments on SB 7 reduced to writing and placed into the journal.
Members heard the motion. The objection. The chair hears none, so ordered. Mr. Kane does not yield at this time, but I will come back and recognize you in a moment. Mr. Kane, proceed.
Section 1.05 mandates that election officials and public officials strictly construe the election code to affect the intent of the legislature, which is found in Section 1.04, which provides that the application of this code and the conduct of elections be uniform and consistent throughout the state to reduce the likelihood of fraud in the conduct of elections, protect the secrecy of the ballot, promote voter access, and ensure that all legally cast ballots are counted. I see Representative Busey there. Due to time restrictions, I'm going to jump to Article 9 of the bill, which begins on page 61. These sections were drafted to give effect to the intent of the Floor Amendment number 7 by Representative Busey. Sections 9.01 and 9.02 are made to ensure that persons 18 years of age or older who are convicted of a felony are fully informed of the conviction's effect on their rights of suffrage. While Section 9.03 also contains a new code provision from the House version of this bill found under subsection A5, which outlaws voting in a federal election held on the same date in this state and another state, subsection C was intentionally and specifically added to clarify what some courts and local prosecutors have gotten wrong. The crime of illegal voting is intended to target those individuals who intentionally try to commit fraud in our elections by voting when they know they are not eligible to vote. It is not intended to target people who make innocent mistakes about their eligibility that are facilitated solely by being provided a provisional ballot by a judge, since federal law requires judges to give someone who isn't registered and requests to vote a ballot. To this end, this provision in the Conference Committee report says that filling out a provisional ballot affidavit is not enough to show that a person knew they were ineligible to vote. For the purposes of legislative intent, this does not actually change existing law, but rather it makes crystal clear that under current law, when an individual fills out a provisional ballot, like tens of thousands of Texans do every year, the mere fact that they filled out and signed a provisional ballot affidavit is not enough to show that an ineligible voter knew they were ineligible to vote, or that their signature on it is enough. That has always been the case. Again, no one should be prosecuted solely on the basis of filling out a provisional ballot affidavit. We also, as part of the conference committee report, discussed recommending to the Secretary of State that these disclaimers about whether or not a person should fill this out be printed larger and more clearly on provisional ballots, since we can't put our election judges in the position of asking voters questions about their status and making legal decisions. Thus, for purposes of legislative intent, we ask the Secretary of State make the relevant text on the provisional ballot affidavit larger and more conspicuous. In total, these provisions strike a balance between allowing the prosecution of people that intentionally vote illegally, while ensuring that people who in good faith cast a provisional ballot but turn out to be mistaken cannot and should not be prosecuted. Such a prosecution, should one occur in the future or have occurred in the past, would, in my opinion, be a grave error. Thus, in reliance on the majority Van Dyke opinion issued by the Court of Criminal Appeals, I know the members of the conference committee believe this applies to all cases that have not yet had a final order. Again, it is our intent to make that clear for everyone. Before moving on to Article 2 of the bill, which relates to registration of voters, it should be noted that several provisions that were found in either the House or Senate versions were omitted from this report because the provisions have since passed both chambers in order, and other bills await for the governor's signature. For example, former Section 2.01, the House version ensures that all voter rolls are accurate by requiring the abstract of deceased voters to be sent to the appropriate authority within 7 days of being created, was passed by Representative Keith Bell in House Bill 1264. Another provision.
Ms. Collier, for what purpose?
Will the gentleman yield now?
How much time? If I could finish 1 second, we'll make sure that we get you a question.
Not at this time.
Anyway, so Article 3 relates to the conduct and security of elections. Sections 3.01, 3.02, and 3.04 contain a floor amendment. It was Amendment 10 by Representative Menjarez, which contains House Bill 752 by Representative Israel. These provisions will save tax dollars by keeping municipalities from spending money on elections when candidates are unopposed. Sections 3.03, 3.12, 3.13 prohibit drive-through voting, which was already not a type of voting which is the law in Texas. While it's lawful for a curbside, and that still is under Section 64.09, to be clear, unlike the language used by the Senate, the conference language does not outlaw the use of mobile homes or trailers for voting. Moreover, this does not outlaw things such like souls at the polls. Realizing there's time expired, and I don't want to ignore you, I would like to yield for questions from Chairman Collier.
Gentleman yields for questions.
Thank you, Chairman Kane. Appreciate you being willing to take these questions. I want to go to page 5, line 16.
Members, please take your conversations outside the rail.
Okay.
Please.
So I was a member of the conference committee.
What page, ma'am?
And, I'm on page 5, line 16 of the legislative draft ending in 396. Is that the one that you have?
Yes, ma'am. Page 5, line 19.
Okay. So I know that we didn't have as much interaction on the conference committee because there were times where I met with Representative Clardy and your lawyer, Elizabeth Bingham or Alvarez, I think that's her name.
Yes.
And then I met with Jatan, and then sometimes I met with you. But I want to be able to make sure that we clear up some questions about the provisions and then also establish the intent, the legislative intent in these provisions. So if you go to page 5, line 16, you talk about enforcement of voter roll maintenance. So this is requiring the Secretary of State to take a proactive step to ensure that the voter rolls match those who are eligible to vote. Is that correct?
I believe that's the intent, yes, ma'am.
Okay, so how would they do that? What does that look like?
Well, the bill shows us that, and depending on what part of the code requires certain registrars to do acts, that's exactly what they'll be looking at. For example, a provision we just went over that requires them to report things to the Secretary of State within 7 days regarding the registry of deceased voters. This would ensure that they did exactly what the Secretary of State told them to do.
So that means that the registrar would report to the Secretary of State?
Well, Yes, they would need to, well, the Secretary of State would review those things. And in fact, one of the really, really important provisions of this section is to require the Secretary of State adopt rules and prescribe procedures for the implementation of this section. That way there's rules to be followed and everyone kind of understands what their duties are. It would prevent the Secretary of State from just making things up.
Okay, so if someone has moved in the transition period, that they're no longer in that one county,
We actually helped fix that by an amendment by Representative John Turner. It's a great amendment. Yes, ma'am.
okay, so I just want to make sure that there's a opportunity to cure if there is a transition period that the person has moved, that the Secretary doesn't completely drop them off, rather the Secretary of State will ensure that they are registered in the county where they actually live now. Is that right?
Under the code, Section 2.02 contains Representative John Turner's floor amendment. That would be amendment number 17, which would do that. It would amend Section 15.02(1) of the Election Code to require that when a registered voter moves to a new county, you might change your license or say no to a jury duty summons by indicating that you've moved. The registrar in the old county may not cancel that voter's registration until they've forwarded the registration to the voter's new county of residence.
So if there's a discrepancy between what the Secretary of State's records show and the local registrar, who trumps? Which one of them prevails? Which record prevails?
Under this exact section, I'm not sure of that, but I would expect that they would look and see which one's accurate and make the determination there. I'm not sure of someone trumping, but I think the goal should be accuracy.
Would they contact the voter to verify?
I hope they would contact the voter. That they should.
But that's your intent, is that they would do that?
But if that's what's needed, yes, I certainly
All right,
hope they do that.
So if you go to page 6, line 24, here in this provision, this is section E, if the Secretary of State determines that a voter registrar has not performed any overt actions in pursuance of compliance with the provisions identified under subsection D4, can you tell me what overt actions look like?
Well, I think in determining the meaning of a word, we look to its context and understanding that the goal of this is not to punish simple mistakes or honest errors, but in realizing that an act that is overt, that is intentional, it is trying to get around the law or skirt the law, or is ignoring rules promulgated by the Secretary of State in that event.
The gentleman's time has expired.
Mr. Speaker.
Ms. Collier, for what purpose?
I'd like to have some more time to vet this bill. I mean, literally, this is very important for all Texans. We need to have the opportunity to clarify and establish the legislative intent. And I did ask for time to ask him questions.
Ms. Collier, an extension of time is not permitted under the rules.
Well, how are we going to establish legislative intent? There's a lot of ambiguities in this bill, Mr. Speaker. Is there parliament inquiry?
Please state your inquiry.
Is there opportunity to have the bill author answer additional questions about the legislative intent and to clarify the provisions of this bill?
Ms. Collier, you will have an opportunity to ask him more questions when he's up here to close on the bill.
Mr. Speaker.
Ms. Collier, for what purpose?
Parliament inquiry.
Please state your inquiry.
Does the time include the bill layout and the time that was made for the motions as well? Is that counted? Or did the clock stop?
The clock did not stop.
So the clock went on, and then the time where he said he wouldn't answer my questions, the clock continued to proceed. Twice when I asked for him to answer my questions, he said no.
Yes, ma'am. The gentleman had the floor the entire time. Chair recognizes Mr. Turner of Tarrant to speak in opposition of the bill. Ms. Beckley, for what purpose?
Thank you, Risco, but I would like to raise a point of order against further consideration of the conference committee report under Rule 13, Section 9A2 and F on grounds that the conferencees have exceeded their authority by omitting text which is not in disagreement.
Please bring your point of order down front.
Man, you see what's going on in Washington, D.C. these days? That place is definitely a political swamp. You're starting to hear things coming out of Austin. It just makes me wonder, if Texas gets its independence, how are we going to prevent the same thing from happening here? I mean, what's to keep us from getting electile dysfunction?
One of the main issues driving Texans to seek independence is how dysfunctional, and in some cases, downright dishonest, our legislature in Washington has become. A recent Pew Public Trust survey puts it pretty plainly. Public trust in the government remains near historic lows. Only 17% of Americans today say they can trust the government in Washington to do what is right just about always, 3%, or most of the time, 14%. A June 2019 University of Texas Tribune survey said about the same thing. Only 24% of Texans hold a favorable view of the federal government. However, sometimes things happen even in Austin that make us want to question if that's just the way it is in politics. While corruption in politics is something we always should be on the lookout for, there are several factors that weigh in favor of an independent Texas. Something that's not well known is that a majority of legislation in Texas is driven solely by the federal government. Surprised? In the last session alone, nearly half of all the bills filed in Texas directly referenced federal law, federal regulations, federal agencies, or federal court rulings. Even more were filed in response to federal bills to make Texas compliant with them. Many people think Texas gets a lot of financial assistance from the federal government. In reality, this is not the case. Texas sends a lot more to the federal government than we get in return, your hard-earned money. After the feds take out their 40% membership fee, they dangle enticements in front of the Texas legislature as a reward for their loyalty. Much of our state policy directions are unnecessarily set just to be in compliance with federal laws or mandates. Think of the additional expense this causes. As an independent Texas, we would be able to set our own direction and create policies that are a perfect fit for us. Also, all that money that's currently going to Washington would stay here to be used to improve the lives of Texans. It's a natural tendency for some to treat a state-elected office as a stepping stone to what they think are bigger and better things. A shot at federal politics. It's almost like they're contestants on a game show, just hoping to make it through to the next round. Often, the things they say and the policy decisions they make are influenced by how much of an audience they will get outside of Texas. They want wider exposure so they can get their 15 minutes of fame also outside of Texas. With an independent Texas, the elected offices here would be the ultimate goal. They would spend all their efforts on making sure the people of Texas are satisfied with the job they're doing.
What do you think about the job Congress is doing in Washington?
Most people have definite opinions on what the federal government is doing these days. Normally, it's disapproval over something, like how they're handling health care or taxes.
How about the property tax reform they were working on in the Texas legislature?
Texans are distracted. We are flooded with news out of Washington, D.C., so our attention is drawn away from smaller issues here at home. Those who stay engaged on state and local issues know this frustration. Low engagement by your fellow citizens makes it easy for elected officials to just brush off your issues because they're not hearing from that many Texans about them. This distraction plays out at the polls as well. With everyone focused on the federal government, even to the point of listing federal offices at the top of the ballot, little to no attention is paid to the down-ballot races. In addition, general dissatisfaction with the federal government leads to disillusioned voters who simply give up and don't vote. With an independent Texas, the distraction of a dysfunctional federal government is gone. Our government would now be the one closest to home, here in Texas. Imagine how people would feel about voting if they actually could make a difference and be involved. It's a hard truth, but it is true. Politics runs on money. You can hate it, you can deny it, but it's the way things work. As part of the United States, political contributions that flow into Texas from outside of Texas are treated just the same as contributions from Texans. Every special interest from the other 49 states starts writing checks to curry favor and get or keep their man in office. These contributions from outside of Texas give the big advantage to incumbents and a major disadvantage to those who would challenge the political establishment. When Texit happens, all that comes to a screeching halt. Donations from outside of Texas will be foreign, and Texas would never allow political contributions from foreign entities. There is no doubt that removing the federal government from the equation should produce better government at home. Independence gives us an opportunity to create a government that is responsive to our needs, meets our challenges, and is the size that we want. To get what we want, we're going to have to be willing to do what it takes to get there. Shouting into the social media echo chamber isn't going to cut it. Outrage on its own is not enough to win the day. Neither is inaction. The way to win is to break the status quo and show your representatives that you're onto them and need to support those who are willing to be accountable for their stance on Texas independence. We have to get out there and work together to shatter the hold of the old political class. Are you ready to get in the fight? Come join with the many like-minded folks at the Texas Nationalist Movement. More information is available online at thetnm.org.
Here's a thought experiment. Imagine for a moment that your state is currently a self-governing, independent nation. It makes its own laws. It controls its own borders. It has its own currency. It has its own trade deals with other nations. It has full control over how, or even if, its citizens are taxed. It has full control over how that money is spent to address the challenges unique to its people. In short, you are just like the other 195 self-governing, independent nation states in the world. You control your own destiny. Now, imagine that the citizens of your independent, self-governing nation were asked to go to the polls and answer one question. Should Texas cease being an independent nation and become a state of the United States? What would be the case for you to vote to give up your independence in favor of becoming a state of the Union? Let's examine the benefits of joining the United States. On day one, you would be subject to 180,000 to 800,000 pages of federal laws and regulations, the true number of which even the federal government can't count. Approximately 5,000 of those laws carry criminal penalties. Be careful, though. The average American commits around 3 federal felonies per day. This doesn't take into account the federal regulatory accumulation that you would be subject to, which has robbed everyone in the union of 85% of their household income. Oh, I forgot to mention the $66,000 you would be liable for as your share of the $22 trillion federal debt. The upside is that this federal debt comes with a handy online scoreboard that can help you keep track of it so you will always know how much you owe at any given time. Ultimately, your fate would be in the hands of one or more of the approximately 440 separate and overlapping federal agencies. If you disagree with their actions, you can always challenge their laws, rules, and regulations in one of their courts, presided over by their judges that you had little to no say in choosing. However, the track record for success when citizens and states challenge the federal government in their own courts isn't great. You could always work within their system to change things, but it'll be tough with your representatives making up a small minority in a body of 535 people, the vast majority of which don't even come from your state. The upside is you get an opportunity to vote for a president every 4 years, who will likely not be from your state, who can overturn your laws at the stroke of a pen with an executive order. All of these functionaries will work together to enforce laws on you and your state that really were crafted to benefit another state or other politicians, but that you'll be forced to obey anyway. The great news is you won't have to worry about all those pesky responsibilities that come with self-government. Nearly half of the bills that your state legislature introduces each session will be in response to some federal law, rule, regulation, or court decision. One caveat, though, if you don't follow the federal lead, they won't return any of the money that you sent to them via federal income taxes. Therefore, it's just best to go along to get along. With membership in the union, you receive access to this wonderful thing called the Bill of Rights that outlines all of the protections of your liberty that you will have as a member. It's been around for over 200 years and it's rock solid. Pay no attention to the asterisks or the fine print. They're only there to guide the federal government on how the federal courts have interpreted each of those rights to make them mean whatever the federal government wants them to mean in a particular situation. No need to worry. So, are you in? How you would answer this question is more important than you might think. Over the last several decades, the world has witnessed an explosion in the number of self-governing nation-states. At the end of the Second World War, there were 54 recognized countries across the globe. At the end of the 20th century, there were 192. In each of those cases, the people demanding their independence were subjected to unreasonable and irrational scrutiny of their desire to be politically, culturally, and economically independent. The scrutiny often came from their fellow countrymen whose opposition was rooted in and motivated by fear. The unfortunate thing about fear is that it is paralyzing. Fear causes people, especially so in the case of major political questions, to make terrible decisions. It causes them to embrace a hated status quo rather than imagine the potential for a positive future. It can, if wielded by would-be tyrants, rob an entire people of their self-confidence and reduce them to a status of willful dependence. It's the political version of Stockholm Syndrome. Thinking about independence in this way may help you and the people of your state reject fear and embrace self-government outside the context of the federal union. for a freedom-loving people who believe in individual liberty and limited government, fixing the federal government and supporting those who promise to do so is no longer an option. Having this discussion right now is a matter of survival. Think about it. If you wouldn't vote to join the United States, why not vote for independence? More information on this and many other topics is available at thetnm.org.
Welcome back, everyone. By now, many of you have probably heard that Texas may look to secede from the Union. This is a new movement now called Texit. And to speak with us about this, we have Daniel Miller. He's with the Texas Nationalist Movement, and he's going to talk to us about his push to make Texas leave the Union. Now, Daniel, real pleasure having you on.
Hey, thank you so much for having me.
So I think a lot of people would have a lot of questions on how this would work, but I think let's start off on how this movement started. Now, I know this is not a new thing for you.
Right.
You've been pushing this now since '96. What has changed between '96 and now?
Well, I'll tell you, there's been a lot. We could talk about how the federal government, the case against the federal government has just gotten worse. We could talk about the increased erosion of our rights and liberties and, frankly, the sovereignty of our state. the destruction of our ability for local self-government. But what really changed in the movement was it was a very conscious choice on the part of those who supported Texas independence to found an organization called the Texas Nationalist Movement that was based on what we had seen happening around the world. You know, at the end of World War II, there were 54 recognized countries around the world, and by the end of the 20th century, there were 192. Those countries did not fall from space. The earth did not get any bigger. They were people in countries or areas that were just like us in Texas that said, look, we just want the ability to govern ourselves the way that we want to be governed. So, you know, looking at examples of that around the world, we made a very conscious decision that a political movement, a political and social movement needed to be formed. And in 2005, that happened. And so since 2005, we've been able to, as the federal government obviously has made things worse, we've been able to engage our case just like any social or political advocacy organization and take our case straight to the people. You look at polling back in 2005 when we started, and you know, any of those polls that were done back then, support for Texas independence was in single digits. But then you look at our on-the-ground work from that point to 2009, you had half of Republicans, about 45% of independents, and 15% of Democrats. Now remember, it's 2009, say that they believe that Texas would be better off as an independent nation. So you see that people were thinking about it from that standpoint.
Wow, that's a pretty good margin actually for you. And what is your estimate in terms of support right now? I understand Texas is a red state and a lot of people aren't happy with the election. How do you think this has changed things?
Well, look, we wouldn't be pushing for a referendum if we didn't think we could win it. You know, the fact of the matter is that we put this thing to a vote. We anticipate we're gonna slam dunk it by 10 to 15 points, maybe more. I think it really depends on exactly what the federal government does between now and the time the vote happens. Does anyone anticipate that they're going to reverse course and suddenly say, you know what, Texas, we get you, we understand your concerns? No, what we're going to get is we're going to get more jobs killed through the Green New Deal. We're going to get more centralization, more socialism, more power sucked into Washington, D.C., and we're going to see the rights of the people of Texas eroded and trampled on. You know, when they're talking about, you know, taking someone like Beto O'Rourke who said, you know, hell yes, I'm going to take your AR-15, right? And when they take these radicals that are in Congress and say, look, we're going to put them in charge of your health and your economy and energy and all of these things, then the people of Texas, you know, we know exactly what we're going to expect. So yes, we'll win by 10 to 15 percentage points and possibly more, depending on exactly how radical Washington, D.C. gets.
Now, what is the first step with this? I understand there's going to be a vote. How does this actually work?
Yeah, it's a process question. We get a lot of those, as you can imagine. But I would just encourage people to look and see what happened in Scotland in 2014, in the UK, and the Brexit vote. It's a very similar situation. For us here in Texas, we don't have citizen initiative. So we can't, no matter how many signatures we collect, we cannot force something on the ballot. But what we have to do is we have to engage these legislators, and we need a statute in place that will allow us to go to the polls and vote for that. Now, good for us, State Representative Kyle Biederman, being the hero that he is, filed HB 1359, which will do exactly that thing. So we make it through the legislature. Texans will go to the polls in November of 2021 to vote on the issue of Texas leaving the Union.
Now, I know with Texas, it's in a unique position as opposed to other states in the U.S. And with the Texas Declaration of Independence, I understand, for example, it actually talks about Texas being able to leave if the standards of government, life, liberty, and pursuit of happiness are not upheld. I understand also that after the Civil War, that there was a new regulation put in for states saying that they had to have a state-by-state vote or basically have to win it through revolution if that's going to happen. How's this work?
That's not it at all.
I see.
And there's a lot of misinformation about that, so don't feel bad.
Okay, yeah, tell me.
Yeah, I got you. So here's what it boils down to. What we know is the United States Constitution in Article 10 lists out all the things that states are prohibited from doing. There's no prohibition against a state withdrawing. It's not in the Constitution. In addition, it says specifically in the 10th Amendment that any powers not given to the federal government by that Constitution are reserved to the people and to the states. So what we have to look at is, from a constitutional standpoint, is what the Texas Constitution says. Now, people want to talk about Texas versus White, that Supreme Court case, and I would love to absolutely slaughter that for you. And we can get there if you want to. But the bottom line is, what's important is our post-Civil War Constitution. Article 1, Section 1 ends with the words, "The perpetuity of the Union depends on the right of local self-government unimpaired to all the states." I don't know of anyone here in Texas that would agree that our right of local self-government hasn't been impaired. So then what becomes operative is Article 1, Section 2. Okay, and that is what I believe to be probably the purest expression of the right of self-determination in a governing document to ever exist. And it's existed in every form of our Constitution since the Republic of Texas days back in the 1830s and 40s. And it says this: all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. And the people have at all times the inalienable right to alter, reform, or abolish their form of government in such manner as they may think expedient. So it's not a question for the federal government or for the other states. This is not a mother may I situation. It is a question that is left solely to the people of Texas. It is a political question, and it's a question that we hope to put to them in a Texas referendum.
You mentioned this Texas versus White. I'm not familiar with it. Tell us about this and what the arguments are with it.
You're a lucky man. So many people here Texas, well, the Supreme Court said, you know, that's what they think that Texas versus White was the end all be all, and they ignore the fact that the Supreme Court is very often wrong about things and has to go back and correct it. But essentially what it was a Reconstruction era Supreme Court case that a lot of these people use to say that Texas can't leave or that Texas needs the permission of the states. Well, it's one or the other, right? So which one is it? Well, that's part of the problem. Part of the inherent problem with Texas versus White is, number one, the Supreme Court, the Chief Justice of the Supreme Court, Salmon P. Chase, had actually been treasurer under President Lincoln, and so he should have recused himself. But beyond that, his opinion that he wrote was so far out of bounds for what the case actually dealt with, and he was in effect legislating from the bench. So much so that you had legislation introduced by northern legislators that was essentially, because of this case, that was calling for an ultimate ban, a reservation on the political power being held in the legislative branch and rebuking the Supreme Court for making the decision. Be that as it may, the opinion itself is absolutely hideous. It's internally contradictory, and I already highlighted part of that. He says that the Union is a union comprised of, it's an indestructible union comprised of indestructible states. And he says, so we have this indestructible union, we have indestructible states, but somehow West Virginia exists. So apparently the states aren't indestructible. But what about this indestructible union? Where does he get that from? Well, he makes this assertion that the United States Constitution is not a governing document in and of itself, that it's merely an amending instrument to the Articles of Confederation. Well, if you follow his logic and you say, okay, Salmon P. Chase, you got us there. Well, then what he did was he just invalidated George Washington's first term. Okay, so because Washington was elected president of the Constitution, 2 states still hadn't joined, and everything under the Articles had to be unanimous. Then you move on to that ridiculous notion, and you say, okay, how does he make that connection? Well, he makes it by saying that, well, the Articles of Confederation said that it was a perpetual union, which we obviously find out because, you had 9 or 10 states have to secede out of the Articles of Confederation to form the actual union under the U.S. Constitution. But beyond that, he says that because the words perpetual union are in there, and the preamble to the U.S. Constitution says it's to form a more perfect union, that somehow he figured out that the founders devised a way to make perpetual even better, perpetual 2.0, right? But what you find is that people that start dealing with this issue, they neglect the fact that he says typically, or he says in there that states can leave, after he says that it's perpetual and they can't leave, he says they can leave by permission of the other states, consent of the other states is the phrase he uses, or revolution. Well, it's like, wait a minute, I mean, that just got a little extra, right? So he contradicts himself inside the document. But more importantly, and this is where the opposition who love to use Texas versus White always wind up on the losing end of this argument. For them, the world stopped spinning. on the issue of self-determination in 1869. But for people like us, the world kept spinning. Supreme Court kept ruling, including the one in Jacobson v. Massachusetts, where it said that the federal government can derive no powers from the preamble to the Constitution. So they utterly cut the legs out from under his entire decision, because his entire decision on this issue was predicated on that belief. So Texas versus White is garbage.
Very interesting. Now, what is the argument to leave the union? Imagine now, I'm a Texan, I'm here, and I'm wondering, okay, not sure what the future of Texas or America is. What do you tell me?
Well, I could tell you just to turn on the news, right? I mean, we could go there. But look, it's interesting, because people want us to sort of come out and say, hey, this is why we should leave the union. And what we feel is it's an intensely personal decision, right? Everyone has their reasons or rationale. But I will tell you that throughout the years, what we have seen are some common threads. People in Texas are sick and tired of living under 180,000 pages of federal laws, rules, and regulations that, if you printed them out and stacked them, would be taller than the San Jacinto Monument. That's the monument to our victory against Santa Anna and our independence from Mexico. And think of that situation when you put it in those terms and realize that we fought a war to be independent from a dictator, but yet the laws, rules, and regulations that it administered upon us, or forced upon us by 2.5 million unelected bureaucrats, dwarfs our monument to our victory for independence. I mean, it should be troubling to anyone, but that's just one aspect of it. Texans are really just sick and tired of being told how to live their lives by a bunch of unaccountable federal bureaucrats. When we have real issues here in Texas related to the border and immigration and so many things that, that nation states of right should, have to deal with, we can't justify overpaying $103 to $160 billion annually into a federal system. That's money we'll never see again. That is the negative economic equivalent of a Hurricane Harvey event hitting Texas every 9 months. I mean, it's like going to a doctor, the doctor drawing all of the blood out of your body, spilling about 40% of it on the floor, re-injecting the rest of it, and then saying, hey, you realize you wouldn't be alive without me, right? I mean, that's how this relationship is. And so, our case is quite simple, but what we do is we boil it down for every Texan out there, and we say, look, we're tired of having to make the case for Texas. We're tired of having to make the case for Texas independence. So we're going to let you make the case for why Texas should be in the union. And we ask them this question. If Texas was a free, independent, self-governing nation right now, right? We had our own army, we had our own control of our own borders, our laws were all made here. We had our own embassies overseas, we had our own passport, we had our own currency. In every respect, we were a self-governing, independent nation. And this debate was not about Texas, but this debate was whether or not we should join the union. What would your vote be? And what would your case be? And it's fun to watch people flip that switch and realize that they can't list really a single reason why they would join the union right now. I mean, think about how unappealing that is, right? Immediately, 180,000 pages of federal laws, rules, and regulations. Immediately, almost $30 trillion worth of debt. I mean, it goes on and on and on. So if you can't make a case for why Texas would join, why would you ever try to make a case that we shouldn't leave?
Now, to what extent is the model for Texas based on Brexit?
Yeah, it's there are a lot of similarities. There are some similarities, I think, probably between a mix between Scotland, the UK, and maybe even the Catalans, but with less unofficial referendum, right? But, we see those similarities in dealing with independence movements around the world. Obviously, the common thread is that of self-determination, but ours is very similar. I mean, if you look at the arguments, say, on the Brexit debate, very similar arguments. An uncaring bureaucracy in Brussels, a massive overpayment that could better be used at home and reallocated, that centralization of power in Brussels that erode the personal rights and liberties of British. I mean, those are very similar. We see similar arguments, especially with the move Colonia, where their argumentation against the Spanish Central, when we first got, personal story, when we first got in touch with that coalition, they sent over some of their material, had translated into English. And amazingly enough, they were making against the Spanish central government. You could have crossed out the proper names and put Texas and put Washington, D.C. in their place, and we could have used it to go out and recruit Texas supporters. I mean, that's how similar a lot of these are. We see it there. We see it with the Sao Paulistas in Brazil. And we see some of the same complaints, especially related to immigration and the border, oddly enough, from fledgling independence movements in the northern Mexican states. So, a lot of this is, we understand that while we're fighting this fight in Texas right now, that it's really part of a much larger movement around the world to reclaim the right of self-government from a bunch of political elites who think they know what's best.
And Texas has an interesting history with this too. I was actually talking to a friend who's a good historian on, the U.S. and Texas.
Right.
He was telling me interesting things about Santa Anna taking over in Mexico, actually, that, for example, he did a ideological purge of the military soon after taking power. He tried taking people's weapons away.
Yep.
You had him there was suspicion of voter fraud, for example. Many of the same issues a lot of conservatives are especially concerned about right now.
Sure.
Texas had actually faced under Santa Anna and under the grounds of them declaring their independence from Mexico. Actually, some of those same narratives from what my friend was telling me could be applied now. Do you agree with this, and to what extent?
Yeah, I mean, I would say that I agree with it, but isn't that really sort of part and parcel of the history of mankind's struggle with how to govern one another? The desire by corrupt men and women to impose their will upon people, and people that typically just want to be left alone. They want to be left to their own devices, and they want to be able to govern themselves in the way that they want to be governed. And so, yeah, I mean, there was definitely some incongruity. When you had Santa Anna and, enacting his edicts that ran counter to the grain of the sons and grandsons of the American Revolution that were populating, that had been invited there to colonize. We're seeing that exact same thing. I mean, we're seeing an imposition of neo-Marxist doctrine, crazy science.
Ms. Beckley raises a point of order as further consideration of the Conference Committee on Senate Bill 7 on Rule 13, Section 9A2 of the House Rules on the grounds of the conferees exceeded those jurisdictions by omitting the text that was not in disagreement. Ms. Beckley points to the text of the engrossed Senate bill and House Floor Amendment number 14 that would enact Section 86.015 Election Code related to the electronic tracking of mail ballots in substantially similar language. This text does not appear in the Conference Committee report. Both the Senate and House versions of the bill are in wide disagreement on the subject of election administration, including mail balloting. The conferees may omit text in the overall context of adjusting differences on a subject matter in disagreement between the two houses. Here, the chair determines that the Conference Committee acted within their jurisdiction in resolving differences on the subject of mail balloting. Accordingly, the point of order is respectfully overruled. The chair recognizes Mr. Zatan to speak in favor of the bill.
Thank you, Mr. Speaker. I'm here to speak in favor of Senate Bill 7. Over the last 5 months, we've spent countless hours going through a lot of the legislation that was filed, exploring a lot of the different issues that have come up over the last decades when it comes to elections. We read through the Baker-Carter report of 2005. We heard the testimony from previous sessions dealing with voter ID, with mail-in ballots, with other issues that we've had with our elections over the last couple decades. And we put together what I believe is a bill that addresses many of those issues. One of the main issues that we found was issues with mail ballot harvesting. And we added legislation that would directly address that and allow the Attorney General's office to investigate and prosecute those issues. We also looked at issues dealing with voter assistance fraud, which is a prevalent issue that targets especially those minority communities and communities where people are taken advantage of. And we we made sure that there was legislation in there to crack down on that, to make sure that we identified those people that were abusing the rights, stealing the votes away from individuals, to make sure that their votes counted. We also made sure to address issues dealing with the mail-in ballots when it's turned into ballot harvesting or to ballot boards and signature verification committee, to make sure that we're protecting those ballots that come back or that their signatures may not match completely, to make sure that there's a driver's license number or last four of the social security number to also help to identify and ensure that those ballots are counted if those signatures don't match. In addition to that, we made sure that the DPS signatures that are shared with the Secretary of State's office is sent down to the counties, and that the ballot boards and the signature verification committees had more signatures to verify those mail-in ballots. This helps to ensure that those mail-in ballots, with both the application and the ballots, come from who they say they are. It protects people's votes. In addition to that, we made sure that we've included statutes dealing with the equipment that we use in our in our polling locations. We made sure that there will be paper backups for every ballot, to ensure that if there is a need for an audit, that there is a way to audit those machines, to audit those votes. So the electronic system tallies up those votes, and then you have a paper ballot backup to make sure you have, as a voter, would have the opportunity to look at that ballot, ensure that's who you want to vote for, and turn it into the machine. In addition to that, we also made sure that during early voting and election days, we've extended the minimum hours that you could vote, and made sure that those hours were between the hours of 6 to 9 on weekdays and 1 to 7. And expanded it on Sundays as well, to make sure that, and also standardized it across the state. This is very important to make sure that people have equal opportunity, no matter where they are in the state, to go and vote. There should be consistency between the counties. So whether you live in Fort Bend County, Harris County, Montgomery County, Dallas County, there's predictability. The Secretary of State also has new authority to make sure that counties are able to both train, enforce, and through auditing process, and if the counties decide not to correct their voter rolls, that there is a mechanism for enforcement. This is important to make sure that our voter rolls are accurate. What currently happens is the Secretary of State will receive information from the Department of Vital Statistics dealing with where people live, where they move, and also death records. And this helps, and when you look at that information, if there are definite matches, then they are removed by the Secretary of State, and when there's not clear matches, then it's sent down to the counties. This enforcement mechanism is important to ensuring that we have an opportunity to make sure our voter rolls are accurate and up to date. And so I would like to encourage everyone to vote in favor of Senate Bill 7. Thank you.
Mr. Pursuit, for a purpose.
Mr. Speaker, I ask unanimous consent that the remarks of Representative Jeton on Senate Bill 7 be reduced to writing and placed in the journal.
Members, you heard the motion. The objection. Chair hears none. So ordered. Please excuse Mr. Moody because important business in the district on the motion of Mr. Turner of Dallas. Is there objection?
Objection, Mr. Speaker.
Please bring the objection down front. Members, there's an objection to the exclusion of Mr. Moody. Is the record vote? The clerk ring the bell. Mr. Landgraf has asked for strict enforcement. Please vote from your desk, members. You cannot vote from the dais. There are 86 ayes, 0 nays. The motion to excuse fails for lack of quorum.
Speaker.
Mr. Tindall, for a purpose.
Parliamentary inquiry.
Please state your inquiry.
We take an oath at the beginning of session, and we collect per diem per day to be here on the House floor to do our job on behalf of almost 30 million Texans. Am I seeing that we don't have a quorum, and essentially it looks to me like the Democrats left the House floor and they're neglecting their duty that they swore an oath to do?
Mr. Tinderholt, that's not a proper parliamentary inquiry. Not every person who left the floor is part of a party or not.
Thank you, Mr. Speaker.
The House.
Mr. Guerin, for what purpose?
Mr. Speaker, I'd raise a point of order of no quorum as reflected on the last roll call.
Please bring your point of order down front. Mr. Guerin makes a point of order that a quorum is not present. Based on the tally sheet furnished by the voting clerk, a quorum is apparently not present. The point of order is well taken and sustained. Mr. Guerin moves the House adjourned at 10 a.m. tomorrow. His objection, chair hears none, so ordered.
people in power, whether red or blue, they could not care less about Texas, me and you. They created this give me country that don't value hard work. For a Texan to survive, all we need are some seeds and dirt. Texan rise, don't you hear your call? Got to save your country, for it's long gone. Texan rise, don't you hear your call? Got to save your country, for it's long gone. We believe in family and we value our community. Gladly lend a helping hand to a neighbor in need. And we don't believe that government should provide for all of society's needs. No, it's the pride of a Texan to give to others voluntarily. Texan rise, don't you hear your call? Gotta save your country, for it's long gone. Texan rise, don't you hear your call? Gotta save your country, for it's long gone. They like our tax dollars and they love our natural resources. They don't want to see us driving trucks, they'd rather see us riding horses. And now they want to ban our guns, you know, especially the ones that look scary. But may I remind you of the Gonzales Cannon and the Alamo heroes we buried. Texan rise, don't you hear your call? Got to save our country, for it's long gone. Texan rise, don't you hear your call? Got to save our country, for it's long gone. This last verse is straight from the Texas Constitution, Article 1, Section 1 and 2. Look it up. Texas is an independent state, yet presently we suffer. We no longer possess the right to locally self-govern. And now it's time as a people in which all political power is inherent. And in such manner we find expedient, we reform or abolish our government. I said, Texan rise, don't you hear your call? Got to save your country, for